Good morning. Welcome to today's meeting of the Public Service Commission. Obviously, today is September the 11th, 18 years since the horrible day that affected our country permanently. I think we all remember where we were that day, and it's a day of remembrance and a day to reflect on many things. I was actually working at the World Trade Center earlier that year, so it's a day that was seared in my memory, and I think everybody should take some time today to reflect on that day. I know my colleague, Commissioner O'Donnell, has some particular thoughts.
Yeah, I didn't have much more to say than that, Mr. Chairman, other than I thought it was appropriate that we remember the day. I know for me, driving in this morning was very difficult, listening to the news, and it's a very emotional day. And I particularly was the Director of Emergency Preparedness at a large nuclear facility in the state of Maryland that day. It was a very emotional and challenging day because we didn't really know what was happening, and we were preparing for the worst as those hours rolled out. So it changed the course of many generations. It will continue to affect this country and the world, and we shouldn't forget the victims and their families and the first responders who continue to die at an early age. So that's all I wanted to say.
Thank you, Commissioner. With that, we will begin our meeting. We have meeting minutes to approve from our last meeting on September the 4th. All in favor, please say aye. Aye. The minutes are approved. Madam Secretary, we have no consent agenda today.
Correct, Mr. Chairman, we do not. We do have a slight change in schedule. Item 5 will be called first. So I am going to call Southern Maryland Electric Cooperative, Inc., filed on July 18, 2019, revised tariff pages. The company proposes to cancel rider OMCE, its optional meter connection equipment rider included as an attachment effective September 1, 2019.
Good morning, Mr. Chairman and Commissioners. David Hoppick on behalf of staff. Southern Maryland Electric Cooperative has filed to cancel rider OMCE. This rider is a pilot program that allows participants to pay for the installation of a generator connection unit. SMECO proposes to remove the rider in its entirety from its tariff, but allow participants to continue to have the generator connection unit at their premises. However, participants would not be allowed to repair the units, and attempting to do so would be considered meter tampering. Although staff agrees SMECO has the authority to cancel the pilot and supports allowing participants to retain the units, staff is concerned about removing the rider in its entirety from the tariff because there would be nothing in the tariff stating the conditions for retaining the generator connection units. Staff recommends that the Commission allow SMECO to cancel the pilot program. Additionally, staff recommends the Commission require to amend rider OMCE to state that 1, the pilot is closed, 2, that account holders may assume ownership of the generator connection units, but may not service the units, 3, must call SMECO if the unit fails, and 4, that SMECO will remove the units free of charge. Additionally, staff recommends that the Commission require SMECO to test all generator connection units that participants choose to assume ownership of.
Thank you, Mr. Hoppick. Counsel for the cooperative.
Good morning, Mr. Chairman and Commissioners. Mark McDougall on behalf of SMECO. SMECO has asked that the pilot be terminated. SMECO also asked that the rider be terminated as well. Our plan was to write a letter to all 237 customers who have these GeneraLink units attached to their meter, telling them that the rider is closed. They may keep ownership of or take ownership of the GeneraLink unit. That the situation will continue, that if the GeneraLink unit no longer functions, we will come out and remove it. If they don't want the unit, we will come out and remove it. Under the program, we have never we have never attempted to fix a malfunctioning unit. We've always removed it and replaced it. Now, over the last 12 years, we have had no new customers in this program. When we started the program back in 2001, we got some customers, but since 12 years ago, 2007, we haven't had any new customers. In fact, the man who is in charge of this program at SMECO has only spoken to, he says, maybe 6 people over the last 12 years who have inquired about the program. So there really is no interest in continuing the program at all. And so we don't see any reason to maintain a tariff for a program that doesn't exist any longer.
Thank you, Mr. McDougall. A question for you. Staff believes that your utility should test all the remaining connection units. What's your position on that?
We oppose that, Your Honor. And the reasons that we do are a couple-fold. One, we presume that the last time that the 237 customers had engaged the GeneraLink unit, it worked. Otherwise, they would have called us about it. The other thing is that by testing it, there are quite a few costs that are involved with it. We have to have a meter technician truck roll come out, which costs about $191. We have to have a service crew come out as well, which is about $255. That's about $446 that we've estimated as a minimum. Times 237 units, it's about $106,000 that we would incur for units that we are presuming worked the last time the customer engaged the unit.
Mr. McDougall, is there a way to tell if the unit, by the customer, if the unit's working or not? Is there a green light or a red light?
There are lights on the unit. There's a green light if it works, and any of the other lights, either one light is call SMECO, or any of the other 2 lights you should call SMECO.
Mr. Hoppick, if that's the case, do we need to test the units if the unit will reveal?
Well, my logic in requesting that was specifically, they're proposing to give the customer a device, but not allowing them to repair it. So if you're going to give something to somebody, but essentially you're not allowing them to try and fix it, they should know if it works. If there's strong confidence that the units in fact work, and there's a sizable cost to doing this check, maybe that is acceptable not to do it. But based on the responses to data requests, basically people don't know if these things are broken until there's an outage, because it's not like they're going and checking the units.
Right, I could see that. When you need a sump pump, it's usually when the power's out and the rain is coming down pretty hard. Perhaps that could be an issue that could be worked into the letter, giving the customer some instructions. Obviously, these customers have had these units for 12, 15 years. They should have some familiarity with how they operate.
We will describe that in the letter, Mr. Chairman. And other complications for testing, the customer must be home because the customer has to provide the generator. The customer has to provide the cord. We will have to turn the power off at either the pole or the transformer in order to test the unit. So there's a lot that goes into it. And if the customer doesn't show up, then we have to come back at another time. So that $106,000 that I had mentioned earlier is really a bare minimum.
Okay. Thank you very much. Commissioner Herman.
Thank you, Mr. Chairman. Mr. McDougall, do customers continue to pay a monthly fee for $10 or $9.95 in the tariff?
Yes, they do.
Okay, thank you. Mr. Hoppick, are you suggesting by not canceling the tariff that customers would continue to pay to $10?
No, I'm not.
So has the staff submitted proposed revisions to the tariff, or do we have to sort of pick and choose which parts remain in effect? Because if the tariff stays in effect, then the $10 with $9.95 remains in effect, doesn't it?
So my assumption was the company would resubmit a tariff filing that removed everything related to payments and so forth, and just remained basically the conditions for retaining the units.
Uh-huh. Okay. So, what tariff service, if it stayed in the tariff, what is the tariff service that SMECO would be providing, assuming that SMECO was ordered to refile and take out the parts that weren't? I mean, what is a tariff service? I mean, it's a tariff, so there's need to be a tariff service, right?
So, you have a situation where you're giving someone something, but you have specific rules specifically saying you may not try and attempt to repair this unit, right? So if we are going to transfer ownership of these generator connection units to the customer, but we're going to specifically have a condition where if the customer attempts to repair the units, they would be engaging in meter tampering, that specific condition, basically we wanted that written down somewhere in the tariff such that there's something specific stating like, you may not do this to these units despite the fact that you own these things.
Right, but again, I'm still, maybe Mr. Spivak can help me out. I'm trying to understand, we have a tariff, we have to have a tariffed service. So what service would SMECO be offering under this tariff provision?
So the service would be coming back out to remove it when it fails.
And that would be the service?
Yes.
Okay. So what if SMECO put in its letter that, and when it wrote the letter, why isn't it sufficient to tell the customer? Because, I mean, I don't know how many customers, are constantly looking at the tariff. Wouldn't it be equally as effective to do what they're suggesting, which is to say, you can have it if you want it. If you don't want it, we'll come get it. Potentially maybe a new provision that says check and make sure it works, and if it doesn't work, let us know, we'll come get it. And why isn't that equally effective to tell them that, if it works now and you want to keep it, but if it stops working, let us know and we'll come remove it because it's not, it can't be repaired or whatever the words are. Why isn't that equally as effective? Potentially even more effective, because the customers who have it are getting the letter versus just sort of a tariff change that they may not even know about.
Well, I assume in both circumstances they would get the letter. The tariff is the written contract, based on my understanding, between the utility and the customer. So having something in the tariff provides a written record of this requirement. And additionally, for example, if someone called the commission with a complaint, the tariff is there to provide reference to how the process is supposed to work. So it's to provide, in the way we record what utilities need to do in their interactions with customers for this specific circumstance, record that similar to, other circumstances in the
Okay.
tariff.
Thank you very much.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I'm struggling with ownership. How do you give somebody ownership of something and then tell them what they can do with it? Just a simple kind of concept. Can you tell me what that theory is? If they own it, to have and to hold, live happily ever after, how can you tell them, how can the co-op tell them what they can do with their own property?
So my understanding, based on conversations with the cooperative and data request responses, is that the unit is between the meter box and the meter. So to get at the unit to actually do service to the unit, you would have to remove the meter.
Well, there has to be some part that the customer has access to because they have to plug a cable into it.
I think that is the part they have.
Well, how can you tell them they can't change the plug on that thing? I don't get it. The cooperative no longer owns it. How can they encumber the use of someone else's private property?
If SMECO were amenable to the customer making a repair to, for example, the plug that would not, in their mind, constitute meter tampering, then, staff would be fine with that. We took the position that they would not be able to repair it because SMECO specifically told us that under their assumption of how this would work, when they transfer it to the customer would not be allowed to repair it.
Yeah, but they don't own it anymore. Once they give it away, they have nothing to say about what's done with it. They have something to say about meter tampering, but that's a different subject.
So,
I'm struggling with this ownership. We're going to give you something, but we're going to tell you what you're allowed to do with it. Can you help me with that, Mr. McDougal?
I certainly will try, Commissioner O'Donnell. There's part of the GenerLink module that extends out from the meter. We didn't think about this, but I imagine if one could repair the module without cutting the meter seal and removing the meter, then that would not be meter
And
tampering.
I've seen electricians replace plug-in
Yeah.
receptacles all the time hot.
Our proposal would be that we would give the unit to the customer. That's our preference. Yet, if the commission would prefer, SMECO would be happy to retain ownership of the module and then, of course, remove it if the customer wanted to, or remove it if it failed to function at any point in time.
Okay, so that leads me, I appreciate that offer to retain ownership if the commission decides, but that gets to liability. Who maintains liability for these things? Well, let me back up. Let me ask you about a response that you gave to staff data request item 1-13, which talks about the failure modes of these units. And the first paragraph of the response is, the failure mode that SMECO has experienced when a customer is receiving service from SMECO has been that the jaws holding the meter blades do not have enough tension, which can result in high heat. In these instances, the units are removed. Who has the liability for any resultant fire or anything else from this high heat, high resistance connection?
Standing here, my legal analysis would be that the customer had did not install the unit. The customer was prohibited from removing the meter from the meter base and removing the GenerLink unit from behind the meter. So SMECO, it would seem to me, if the facts were such that there was negligence or some legal liability involved, the customer would not be held liable.
Yeah, I'm not sure that's going to be memorialized anywhere.
No. Like I say, if the commission would prefer, SMECO can retain ownership of the unit. But
Did SMECO consider just taking all these things out, since they have this failure mode and
we did consider that. The balance to that was these customers have paid for these units over time. And we didn't want to say to them, you've paid for this, but now we're removing.
Well, that's standard practice. Certainly, I think of my cable top box. I paid for that thing. Chairman and I were talking. We paid for our cable top set boxes probably 10 times over the years, and we still got to give them back to the utility when we're done with them.
Well, that certainly is an option, and I don't object to that either.
Okay, there's a lot of questions here that are just troubling to me. How do you control someone else's property?
So
Basic concept.
we could eliminate the property question by SMECO retaining ownership of the unit.
And you could eliminate the failure mode if you took them out.
That's correct, and we'd be happy to do either one that the commission would like.
Do you know what the cost is to take these things out?
I'm going to ask Mr. David Johnson to come up here. Mr. Johnson is SMECO's Automation and Meter Operations Manager. He's in charge of this program, and he knows more about the operations of it than I do.
Right, so the cost of it would be a truck roll. It would be the $190 and some change that we put into
And you have 200 of them,
237 of them.
237 times 200, say, for round purposes. Okay. So that gives us a sense of how much it's going to cost. Not a huge figure, so that doesn't scare me. But the questions that it clears up certainly seems worth the expenditure. I don't know.
So Commissioner O'Donnell, if that clears the question up for you, and it's something that the majority of the commissioners would like, we can remove all of the units. And in preparation for that, we would write the customers a letter explaining the background that we're terminating the program, et cetera.
Sometimes we encounter stuff that happened, I don't know, maybe 16 years ago or 15 years ago or 14 years ago, and we say, what were they thinking back then, or whatever happened to that program, or who lost track of that? And I can envision this program 15 years from now with a half-active tariff and installations that are owned by the customer but can't be touched by the customer. That there's a lot of questions that arise legally and physically, mechanically, that just troubles me a lot.
It makes no sense for the cooperative to continue the program, and the most efficient way out of it is something that we are willing to embrace.
Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner Richard.
Yeah, I wanted to just follow up on one of the questions that Commissioner Herman started, and that is I think you answered that currently the participating customer is paying the $9.95. Is that correct?
That is correct.
Okay.
Customers had the option of paying up front, and I forgot what the fee was, that they paid up front, a one-time fee, or they had the option of leasing over the course of time.
Yeah, and in just looking at some of the data request number 1-11, am I reading to this to understand that all the real capital costs for these devices, they were paid by 2011, is that correct?
They're fully depreciated.
Okay, so if we were to have this, requirement to test all the units, why wouldn't that just be a cost to the program? And isn't there sufficient money being collected, and hasn't it been collected since 2011 to cover, the $106,000?
Well, the cooperative doesn't take the $9 and change every month and put it into a bucket for continuance of the program. It is used for other portions of the company's business, and if it's not used for the company's business in a particular year, the board of directors allocates that to a capital credits account, which is later given back to our customers.
Okay, so the company's benefited then from this
we-
funds in the past, but to complete this program, I mean, wouldn't then this just be a cost that would have to be covered by other
It would be an
revenues that
additional
come in?
cost.
So,
It would be an additional cost that the customer.
okay, but the company has received this money, and therefore it's not like you'd suddenly have to again just create the $106,000.
No, we would pull it out
You've
of
actually
operating.
earned this money in the past directly from this program.
Yeah. As I was saying, the revenues that SMECO, that a cooperative doesn't use for its annual expenses, gets funneled back to the customers through the
Yeah,
capital
and they've
credit.
benefited then in the past.
They've
So-
benefited from that to an extent that you couldn't. I mean, there are so many decimal points you can take
Okay,
down.
right, and then now that there'd be potentially another cost that they would have
It would just
to
be
assume
another
this
cost
year
that
if we were to
offsets
just
the
go
fee
ahead,
capital credit.
okay,
That's
from this
correct.
program. Okay, I don't have any other questions.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman. I'm curious about the failure rate for these products. Do we know if have there been any safety issues or safety concerns with them? Have there been any situations where if one has failed and has caused a problem?
Mr. Johnson sat down just a shade
he
too
sat-
soon.
Okay.
Okay.
No, so we have not seen any safety. We have not had anybody, any arcing occur from somebody using these devices. The devices themselves, yes, we have seen failures of those. The disconnect not working, the power cord not making good connection, bugs, building nests inside the units, things like that.
Okay. So you haven't had anyone sign up since 2007. And I saw your data response in terms of your concern, your thoughts about why that hasn't happened. But I also noticed that you hadn't filed any kind of report or update about the pilot. Do you think there's any lessons learned, anything in this pilot that needs to be presented to the commission?
No, sir.
Nothing at all? Nothing? I mean, it's been a long time. You've had several hundred customers. There hasn't been
I
anything?
mean, lessons learned as to why we shouldn't continue with the program, or why we should continue with it? Or
Well, just in terms of the pilot as a whole, to my knowledge, with the exception of this filing and I guess the original filing, doesn't appear as though there's been any other kind of report or update about the project itself. What happened with the pilot? Has it been successful? Do you think it's been successful? I mean, I know we're canceling it now.
We saw
but-
very little participation in the pilot.
Mhm.
And the ones that we did see go in, we had issues with the units. One of the issues was the cord plugging up into the unit. It actually has a little plunger inside, so that if you don't make good connection, you actually have to shove up harder on the unit. So that's always been a safety concern for us, that, you have a customer shoving up on an unfused device, because they are working at the utility side versus behind the main breaker. So, I mean, that's always been a concern for us.
All right, so this device is actually behind the meter, but it's in between the meter box and the meter.
That's correct. Yeah, so it's in an unfused state.
Did the company place, no, Smeco has smart meters now. Did you place smart meters on top of these devices?
Yes, we did.
All right, thank you.
Can I ask the life expectancy of these units?
According to the manufacturer's documentation, it has about 30,000 cycles. So it would depend upon how often they use it.
So there's not a life expectancy in terms of years.
No, they only give like a year's warranty on the unit. The manufacturer only supplies a year's warranty.
And how many of them have been removed for failures of the original that were installed?
We only have data that goes back to 2007, so it's been between like 7 and 9 units that have been removed since then.
Thank you. Commissioner O'Donnell. Oh, what do you got?
I'll defer.
Commissioner Richard.
I'm sorry, I just wanted to follow up on a question that Commissioner Linton just asked. So are you saying that one of the things you did learn from this pilot is that perhaps this solution, the GeneraLink, is not the best and safest device that compared to like another connection solution for these generators?
We haven't had a customer have an incident from using them.
Okay.
The concern that we have had is that, if you got a person out there and they're actually shoving up on this connector so that it makes good connection, could they cause something to happen in an unfused environment?
But there's got to be a connection in some manner. I mean, whether you're having an electrician come out and connect your device, your generator, are there better, safer solutions than what your pilot
Yeah.
tested?
You're behind the main at that point. So whatever the electrician does, he puts in behind the main breaker.
Okay, and that's better. That's
Absolutely.
oh, it is. Okay. Oh, thank you.
Just a couple follow-ups, if I might. One, these indicating lights you said are on these units, do they only operate when the system is, when there's current flowing through that connection that's hanging out there?
Yes, so the green light tells you whether the utility power is on or not. The yellow light is an indication of how much current is flowing through the unit, and the red light is a failure mode.
Okay, but my question is, if they're not on every day, they're just on when you're using the unit, right? When you're plugged into it, is that right, or no?
The green light will stay on all the time.
All the time. Okay, so that light probably has a life expectancy. Okay.
And that's part of the test, that we would have to shut the power off when we go out to be able to test that status light.
Okay. Staff, I wanted to ask you another question. Did you consider, so you required these notices to the current customers But what happens 20 years down the road when the house has changed hands 3 times and so there's a new owner in there who was not part of any of this? How's that work?
Well, I think that argues for retaining something in a tariff describing the circumstances of if they are allowed to retain these units, the circumstances under which, they can or cannot repair the units, what needs to happen if they repair the units.
I would suggest it argues for just taking them out and making it clean and doing away with that portion of the tariff completely, and then you don't have to worry about it 20 years down the road.
So staff mentioned that option in its comments on the last page, and we would not be opposed to ending the program while simultaneously removing all the units to deal with this.
There's going to be another commission sitting here 15, 20 years down the road, and they're going to wonder, what is this thing we have here? And especially if a house burns down because of it. You got a failure mode right here that says you have a high heat failure mode.
It is, and it's certainly something you want to consider. Just one bit of a reminder, if the commission does go that route, though, that ends up requiring people who have generators to call in an electrician now and get a new setup to do it. Whereas retaining these in place and allowing them to keep it might allow them to postpone that expense indefinitely.
It might be the more responsible thing to do, considering the co-op just said that that's a safer option.
It might, Commissioner. It might very well.
Mr. McDougall, can you respond on that point regarding removal of all 237 units?
SMECO is willing to remove all 237 units if the commission were to issue an order terminating the tariff.
Thank you. I would lean in that direction if the utility is putting that on the table.
And we would write a letter to each of the 237 customers explaining the termination of the program, the elimination of the tariff, explaining that we will be removing the GenerLink module. They don't need to be home for us to do that. We go out and we take off the tag that's on the meter, remove the meter, take off the GenerLink module, and put everything back the way it would otherwise would be.
I'm sorry, Mr. McDougall, your last statement I missed.
I'm sorry, Mr. Chairman. The customer does not need to be home in order for us to remove the GenerLink module. We would go out to the customer's residence. We would cut the seal, remove the meter, take out the GenerLink module, put the meter back, and reinstall the seal and leave the residence.
Okay, thank you, Mr. McDougall. This is what I will propose. I thought this was going to be a more simple case, but obviously there's some information at play regarding these just 230 some odd units. I would ask that that we would continue this item for a couple weeks to give the parties, staff council and the utility, more time to consider the application that SMECO has made before the commission, propose any changes to that. That'll also give the time for the commission to have additional deliberations while the parties have discussions, and we could come back at a time of your choosing upon notification to the executive secretary.
Thank you, Mr. Chairman. Might I ask that would the commission prefer for SMECO to refile its application seeking a termination of the program, elimination of the rider, and proposing that we take out all 237 GenerLink units, rather than transferring ownership as we had in our original filing? Or is that something that we can...
I did not hear from every commissioner on the point of ownership, but and perhaps if commissioners wish to speak on that point, but I do agree with Commissioner O'Donnell that it would be cleaner if the utility, if it seeks to retain these units, retain ownership and not transfer them to the customer.
I think you were both correct.
With regard to the removal, I think that's a discussion that you could have with staff council. And if you seek to make a revised proposal, you could do so. If not, that is your choice as well, and then we'd revisit this when you're ready. we'll be in a better position to make a informed decision than rather on the fly today.
Thank you, Mr. Chairman.
Okay. Thank you. So I guess we don't need a motion, Madam Secretary. Just be on the lookout.
We'll defer it, but unfortunately, in order to keep track of this so it doesn't fall through the cracks, we would put this reschedule it for a admin in 3 weeks. Of course, if the parties aren't ready or they'd like it earlier, then they can just contact the Executive Secretary's office.
Thank you. Does that sound good to both sides?
I don't know. I don't have my calendar in front of me, but
Okay.
I would certainly a deferral to a date certain would work.
Date
for us.
certain, and if you need more time, you have more time.
Thank you.
Okay. Thank you.
Thank you, Commissioner.
Thank you.
Returning to the order of the administrative agenda, the next item is Zayo Group LLC and Front Range Topco Inc., filed on July 9, 2019. Its joint application for approval of a transfer of indirect control and to participate in certain financing arrangements.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by Front Range Topco Inc., I'll refer to them as Front Range, and Zayo Group LLC, I'll refer to them as ZGL, that request approval from the Commission for, one, the transfer of indirect ownership of ZGL to Front Range, and we refer to that as the transaction, and two, for ZGL to participate in certain financing arrangements upon completion of the transaction. ZGL in Maryland provides local exchange services pursuant to authorizations granted by this Commission. As a result of the transaction, ZGL will become an indirect, wholly owned subsidiary of Front Range. The parties also request authorization for ZGL to participate in new financing for up to $11 billion. Turning first to the transaction, as explained in staff's bug sheet, the two key factors here are, one, the transaction involves the acquisition by a stock corporation, Front Range, of more than 10% of the capital stock of a public service company that operates in Maryland. That would be Zayo Group Holdings, which is the parent of ZGL. The second key fact here is that the stock is being acquired as collateral security, and we got that information directly from the applicants. Consequently, the transaction requires approval under PUA 6-101C4. The transaction does provide ZGL with additional financial and operational resources. Therefore, the transaction is in the public interest. As a result, the staff recommends that the Commission approve the transaction. Turning now to the financing. The financing transaction by a public service company requires Commission approval under the Public Utilities Article unless three conditions are satisfied. The financing by Zayo and the other related entities satisfies these conditions for an exemption, which include, one, the transaction has been approved in another state; two, the public service company's revenues are less than 3% of the gross revenues of all public service companies in Maryland; and three, the public service company notifies the Commission of the financing. The financing does give ZGL capital to invest in its facilities and for general corporate purposes. Therefore, we believe the financing is in the public interest, and we recommend that the Commission note the financing. The last item here is the Commission, in a 2015 notice in connection with the deregulation of inter-exchange service, stated, quote, by July 2015, carriers with a combined exchange and inter-exchange tariff shall file proposed tariff revisions with the Commission to remove the long-distance portions from its tariff. In response to a staff query, ZGL said that it will file a revision to its tariff to delete a reference to interlata service. Staff believes that removal of all references to interlata service in ZGL's tariff will comply with the Commission's directive. Therefore, staff recommends that the Commission require ZGL to file revised tariff pages to remove all references to interlata service.
Thank you, Mr. Albert. Is counsel for the applicants present? Seeing none, do the commissioners have questions? Commissioner O'Donnell.
Just a quick question. I'm pretty sure I know the answer to this, but I want to kind of just say it for the video record anyway. We're approving the transaction, which I think you said also includes setting them up for a better financial situation. My words, but I think it captures what you said. But that doesn't mean that we're approving, when we approve the transaction, we're not approving the financing associated with the transaction.
That's correct. Under that three-prong criteria, which in every situation I've been here, has been satisfied because of that 3% threshold. They don't require commission authorization, so we simply note the financing.
Okay, so we're noting the financing, we're not approving the financing. I just wanted to clarify that. I thought I knew that, because anytime I start talking about noting or approving $11 billion worth of financing, I get a little nervous, so.
Yeah, that's right. I mean, it's emphatically a situation where we simply note it. They don't need our authorization. We don't, frankly, we're not authorized to grant the authorization.
Thank you.
Is there a motion?
Yes, Mr. Chairman, I move that we approve the transaction, note the financing, and direct Zayo Group LLC to file revised tariff pages to remove all references to interlata service.
Thank you. All in favor? The motion is approved.
The next item is America Approved Commercial LLC, filed on July 9, 2019. Its application for a license to supply natural gas or natural gas supply services in Maryland.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is the gas supplier license of America Approved Commercial LLC. America Approved Commercial seeks to provide gas broker services to commercial and industrial customers in all the utility service territories where gas choice is available. By statute, the applicant for a gas supplier's license must prove technical and managerial competence, financial integrity, and willingness and ability to comply with the applicable federal and state laws and regulations. Staff has reviewed the complete application and believes America Approved Commercial has met the requirements to be licensed as a gas supplier limited to broker services. America Approved Commercial has provided a $10,000 bond to meet the financial integrity requirements for brokers. The company does not yet have training and marketing materials applicable to Maryland. Staff recommends that the Commission grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services. Additionally, staff recommends that the Commission direct the company to provide Maryland-specific marketing and training materials 30 days prior to utilizing the materials in Maryland, and to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you, Mr. Spivak. Do commissioners have questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask about the buck sheet on the complaints section. So that and the managerial competence section both say that this company does business in Maryland. Are they an electricity broker, or what are they?
Good morning, Chairman, Commissioners. Paige Shaw on behalf of staff. Yeah, the company is currently an electricity broker in Maryland.
Okay, so then we would have any complaints filed with our CAD.
Yeah, the company doesn't have any complaints against its
Okay.
electricity.
The only reason I wasn't sure was because on their application, under the question on page 4, which states which the applicant now or has been engaged in the retail sale, including brokering of electricity or natural gas, they list all their licenses and their license numbers, but they don't list Maryland. So I wasn't sure if they were licensed here or not as a broker. Very good, thank you.
Thank you, Ms. Shaw. Is there a motion?
Mr. Chairman, I move the Commission grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland. And finally, direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. All in favor?
Aye.
The motion is approved.
Thank you, Commissioners.
The next item is Marathon Power LLC, filed on August 9, 2019. Notice of updated supplier information and request for a letter acknowledging registered trade name.
Good morning, Mr. Chairman, Commissioners. James Greger on behalf of staff. This item concerns a notice to update supplier information, specifically a registration of a new trade name. Marathon Power LLC holds licenses to supply electricity or electric generation services and natural gas or natural gas services in Maryland. The company has notified the Commission that it has registered a new trade name, Marathon Energy. A notice of the trade name was sent to customers on August 1st, 2019. Marathon states that the change will not affect current customers' energy services. Staff has reviewed the Maryland Department of Assessment and Taxation's database and confirmed that Marathon Energy is still actively owned by the company. Marathon owes $10 in outstanding commission assessments and has no open complaints as of August 29, 2019. Staff has informed Marathon of its open assessment. Staff recommends that the Commission note the trade name. Thank you.
Thank you, Mr. Greger. So we're still short $10?
We are, Mr.
Okay, all right. This isn't the same Marathon Petroleum, I imagine. This is the big multinational conglomerate.
No.
Oh, okay, all right, so maybe they don't have the $10. Do commissioners have questions? Is there a motion?
Yes, Mr. Chairman, for item number 3, I move we note the trade name.
Thank you. All in favor?
Aye.
The motion is approved. Thank you.
The next item is ATC Outdoor DAS LLC, filed on August 12, 2019, replacement MD Tariff Number 1 in its entirety with MD Tariff Number 2, effective September 13, 2019.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by ATC Outdoor DAS LLC, I'll refer to them as ATC, to revise their tariff. ATC eliminates the portion of its tariff that describes intralata tolls. Elimination of this language is justified due to the 2015 law that I referred to earlier in connection with the ZAO filing that removes Commission jurisdiction over intralata tolls. ATC also adds tariff language to address distributed antenna systems. Staff recommends that the tariff sheets be accepted for filing with an effective date of September 13, 2019.
Thank you, Mr. Albert. Do commissioners have questions? Seeing none, is there a motion?
Yes, Mr. Chairman. For item number 4, I move that we accept the tariff 4 filing with an effective date of September 13th, 2019.
All in favor? The motion is approved.
The last item on the agenda is Office of Staff Counsel, filed on August 27, 2019. The 2019-2020 SOS Bid Procurement Improvement Documents, case numbers 9064 and 9065.
Good morning again, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is the results and the report of the 2019 edition of the Commission's annual procurement improvement process for standard offer service electricity. Essentially, this provides the documents that are needed to conduct the annual SOS bidding that occurs 4 times per year in Maryland. Each year, staff convenes a group of interested stakeholders to consider revisions to the process, generally of ministerial or fairly minor nature, to constantly tweak the process to make it a little better every year. And that's what happened this year. We did have both a meeting and a conference call, and there were several changes or small changes adopted to the process for which the parties are now seeking Commission approval. Those changes are detailed in staff's report on the process. The first is simply the change in the bidding schedule for the upcoming year, 2019 through 2020. I do note that there is one unusual aspect to that, which is that the April bidding is given alternative schedules. And the reason for that is because we don't know when PJM is going to be doing its bidding for the base residual auction, and that has some impact or potential impact on SOS pricing, and we wanted to accommodate that if possible. The second tweak to the process is that bid eligibility applications should be submitted 10 business days before the bidding occurs. Previously, it was 10 days. The effect of that essentially is to eliminate the effect of having a holiday within that 10-day period. The third change is just to specify more clearly when the eligibility deadlines for the January, April, and June auction participation are. A fourth change is providing an email option for partially executed transaction confirmations. Transaction confirmations being the documents that winning bidders submit once it's been confirmed that they've won. A final change requested is that the transaction confirmation forms specify the appropriate PJM P node for settlement for the power purchase in question. Those were all of the consensus changes that were agreed within the procurement improvement process. There were a couple of non-consensus issues raised, but it is staff's understanding that nobody is pursuing those at this time.
Thank you, Mr. Spivak. I'm glad to see we're advancing from fax machines to email at this point. Your recitation summarized nicely your memo, so I have no additional questions. Commissioner Herman.
So I just want to clarify, Mr. Spivak, that the bid documents, because it was, the bid documents do not contain either of the non-consensus items. Is that correct?
That's correct, Commissioner.
Okay. And if we move to approve the bid documents, you had a proposal that the utilities document the occurrence of situations about the telephone calls to suppliers.
Correct.
Which was one of the none. Is that, have the utilities already agreed to do that, so we don't need to include that in the motion? How is that?
It would
set
probably
up?
actually still be helpful for you to include in the motion. I think the utilities have agreed to do that. They certainly did not seem to have any objections to it, but it would be worthwhile to memorialize in the Commission's resolution.
And with respect to the contingency bidding, nobody's pursuing that since nobody's here and no one's filed any comments to support the elimination of the contingency bidding. So that's just,
That is correct.
we're waiting on that one. Okay, thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask about the non-consensus item that we didn't really talk about because it concerns me. So the second proposal staff objected to was to authorize the utilities to call suppliers from the bid room whenever questions arise regarding A, bids received, or B, if collateral was posted, but no bids have been received. I wanted to ask you about that a little bit. First of all, is this the first time the utilities have proposed this?
Well, I think there is a perception among, and maybe a reality, that up to a couple of years ago, things were a little more lax on that type of contact occurring from the bid room when there was something that the utilities felt the need for confirmation about from bidders. And we did have the issue come up a couple of years ago, and I think at the time it was raised by the Commission's SOS consultant and staff. And the Commission was concerned about any excess of communication occurring from the bid rooms between the utilities and the bidders. So, essentially, it was determined that it shouldn't happen unless the bid monitor specifically believes it's necessary. I think is how it works now, and
So have
I
the
think staff
utilities-
is happy with that limitation.
Have the utilities proposed this before or not?
Not as far as I'm aware.
All right. So I'm surprised they've proposed it now. And of course, we're right in the middle of the process of, or the utilities are in the process of obtaining a new consultant. So that process is occurring right now. Do the utilities understand that at least one commissioner, and I think maybe more than one, view communications outside of the bid room as a vulnerability to the integrity of the system?
I think they may understand in principle, but it does not hurt to be reminded, Commissioner.
That's part of the reason we're having this discussion right now, because I'm sure that they're listening, and I'm sure that they know that We're not going to get lax on communications during the bidding process outside the bidding room, especially when there are affiliates. And that I would hope that any new consultant, if we get a new one, maybe someday, would feel the same way that the current consultant feels. Because I think that that's extremely important, because keywords, code words, signaling are all, I'm not accusing anybody of anything, but they're all vulnerabilities that exist. And if anything could destroy the SOS bidding process, it would be a breach of the integrity and viability of that system. So,
Well, I think I can honestly state that staff is in complete agreement with that sentiment, Commissioner.
good. Thanks for engaging me on it. I appreciate it.
With that, is there a motion?
Yes, Mr. Chairman. Mr. Spivak, I'm not going to direct the utilities to do that. I think if they are the proponents of such a change, then I think that they can demonstrate that. It would be on them to demonstrate it, so I'm not going to make that part of the motion. And therefore, I move that we approve the 2019-2020 SOS bid procurement documents.
All in favor? The motion is approved. Thank you.
Thank you, Commissioners.
Seeing no additional business, this meeting is adjourned.